The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Everyone, please be seated. This afternoon, we have 2 cases set for oral argument and 2 cases that will be submitted non-orally. The first case that will be heard is Polar versus Okoboji Classic Cars. And the second case for oral argument is Buboltz versus Barusinga and others. The 2 non-oral cases are State of Iowa versus Bear and Merrick versus Johnson. At this time, Justice Apple is participating by Zoom, and so I want to make sure and do a quick sound check. I will ask, we'll start with Mr. Talsma. If you would please do a sound check.
Can you hear me okay?
I can. Thank you, Counsel.
Thank you.
Thank you. And Mr. Sease, if you would like to do a sound check, and then when you're ready, if that's successful, you can begin.
Okay. Can you hear me, Justice Apple?
I can. Thank you.
Your Honor, may I take off my mask to argue?
Yes, you may.
Okay, thank you. Madam Chief Justice, and may it please the court, my name is Matthew Sease, and I represent Al and Deb Poller in this matter. Today, we ask that this court vacate the Court of Appeals decision and reverse the decision of the district court and remand for a determination regarding damages. We ask this for 3 primary reasons. First, we ask that this court find that Okoboji Classic Cars, or I'm going to refer to them as OCC throughout these arguments, violated Iowa Chapter 537B. Second, we ask that this court find that Al and Deb Poller suffered an ascertainable loss within the meaning of the Iowa Consumer Fraud Protections Act. And third, we ask that this court find that because of OCC's violations of Iowa Chapter 537B, that a judgment cannot be entered against the Pollers for any claimed damages by OCC for unauthorized or for work that was performed by OCC. Iowa Chapter 537B is designed to be a robust consumer protection act for individuals seeking to get or have their automobiles repaired or restored. And
well, you say restored, but that word isn't in the statute, is it?
It's not. It's service or repair. But we believe that the only proper interpretation is to have restoration work such as Okoboji Classic Cars be incorporated within the terms of that statute. And that's consistent with courts throughout the country that have had the opportunity to look at that question. Additionally, I think it's a distinction or a definition without distinction from repair and restore. I think that we can easily get down a slippery slope of what's the difference between a repair or a restore and its applicability. And I think if you look at the purpose and the intent of this statute, restoration work would have to be included within that.
In this case, just kind of walk through how should things have worked? Because, you know, this was what an 1931 Chevrolet, and obviously when OCC took it in, they didn't know how much it was going to cost at that point to restore it. So how should things have worked? How should they have proceeded in terms of communicating with the Pollers?
I question a little bit of whether OCC could actually not provide an estimate in this. They're in the business of restoring antique and classic cars. While they may not know the full extent of that, an estimate, I think, is an appropriate thing to happen. And so I think if you read Iowa Chapter 537B and look at what the estimate requirements are, OCC could have looked at this and said, this is going to cost more than $50. And we have 2 options at this point. The consumer, the Pollers in this instance, can provide either a written authorization or a contract of some sort that is going to allow us, OCC, to perform the work on this car. Or we can say, you can authorize to do this orally. But in either instance, we have to give them what's statutorily mandated about their rights, which include they have a right to a written estimate, they have a right to an oral estimate, or they have a right to be notified
But
if.
counsel, doesn't a party have a right to waive those statutory rights? Why couldn't they move forward here and say, okay, we asked for an estimate, you said you won't give us one, we're still willing to move forward with you? Why can't they do that?
I think it has to be an informed waiver. And that is where the problem lies in this. And what this statute, if you look at the case, the Lynch case that came out of Wisconsin that was cited in the Court of Appeals argument in our briefs, they talk about this being an informed consent statute. And in order to proceed in any way under this statute, you have to have an informed consent, which means, just like in the medical malpractice context or anything else, you have to have full knowledge and understanding of what rights you may be waiving. And that is the problem with this.
So counsel, does that mean that your client is entitled to $112,000 worth of repairs? Your side of the story is you didn't have informed consent, the statute has been violated. So therefore, you now have a car that has $112,000 worth of improvements and owe nothing?
Well, right now, we don't have the car, Justice Apple.
Well, okay, let me put it to you in the hypothetical then. Supposing a car is repaired to $112,000, but there was not the proper disclosure under the statute. You got none of this informed consent that you're talking about.
Yep.
But you got the value of the repairs, and they were authorized in the sense of at least they go ahead and fix it. Is it your position then that the owner of the car would own the car with all $112,000 worth of repair, nothing owed to the?
Potentially, that is an option. And if you look in at least one of the cases that we cited, I believe it was Austin, which was a Florida District Court opinion, and they go into an analysis of this exact issue. Now, granted, the damages at issue in that case were significantly less, somewhere around $2,500 or $3,000. But what the district court did in that case is said, we're sorry, but there's a balancing act that happens in this, and what the legislature has said in developing these types of statutes is we're putting the onerous on the car repair shops to do this. And so what happened in that case was the statute, which was much like the Iowa statute here, said that any repairs over $50 have to follow through with these estimate things or these estimate requirements that are outlined in this Iowa Code, Chapter 537B, and said, repair company, you're only allowed to recover $50 for this. And we understand that that's not a good thing for businesses, but that's what the legislature required to provide consumers the protections.
You understand the dilemma here, which is, on the one hand, I will say if there was a violation, which, we have to get through that issue, but if there was a violation, if OCC didn't comply with the statute, then I'm very troubled by the Court of Appeals approach that, well, because they went ahead and did the work, you owe the full amount of money anyway, because that leaves your clients without any remedy for a statutory violation. On the other hand, it seems not fair that they get a fully restored car for free. So, I mean, is there some position in between that we can latch onto?
I like to think yes, and I think that it's yes, but it's a little bit harder road to go there for me based on the credibility findings that were done by the district court. Because what my clients testified to, as Al and Deb Poller, is that they believed that this restoration was going to cost around $45,000, and we had testimony from them that they believe they were told that by OCC personnel at the time. And what happens in that situation when you look at cases that have decided this, and what I think is probably a somewhat easier case for everybody to understand and apprehend, is when the estimate or the final bill ends up being so much further above the estimate that what courts have done throughout the country in those instances is saying, we're only going to hold the consumer responsible for what they thought the estimate was. This is a little bit more of a difficult situation based on the district court specifically finding that that he didn't believe that estimate conversation happened.
I find that interesting. You keep using the word estimate. It seems to me that you want it kind of both ways. The letter by the Okoboji was pretty clear. They said, we don't do estimates. Kind of like, we don't do windows. We don't do them. And yet the relationship continued, and they even shipped the car out. And I find it interesting that you're talking about estimates, but saying there was no estimate. How about when Justice Mansfield was saying, is there something in between? How about figuring out from the billing what exceeded $45,000 and having Okoboji remove that part of it and sending back what probably is somewhat of a shell?
I think, I mean, that would be a possibility. I'm not sure how we do that in the sense of things like upholstery work and paint work and things like that.
I'm thinking taking chairs out, and from what I read, there was a lot of parts, big included pieces that they had to actually find, engine parts. I mean, your client would probably would definitely get a car that doesn't work.
Sure.
And Okoboji would get a bunch of pieces to a vehicle that they'll probably never have another one they can use it for.
I think that's a possibility. Another option that I think is to kind of go along with what Justice Mansfield was asking. If the court was to determine that there wasn't an ascertainable loss, which, and I am in no way conceding, I don't think that that's appropriate. But this is part of what I think is the flaw with the Court of Appeals opinion, is the marrying of the consumer fraud action to the defense of ours, to OCC's breach of contract claim. We have pled as a defense, and what our defense has been all the way throughout the trial is Okoboji Classic Cars does not have a proper breach of contract claim against us because they have violated the consumer fraud statute and Iowa Chapter 537.
The writing that OCC provided, it was a time and materials agreement, is that right?
I don't.
It was, they quoted time and materials.
Exactly, at $65.
I understand you'll contest
Yeah.
whether that was an agreement.
Yes.
And was the hourly rate set forth in that writing?
It was.
So help me with this. I thought the statute allowed for communication of an hourly rate in lieu of an estimate.
It does provide that, and it says that can be provided, but the problem is that it doesn't mean that if that's how it's going to be provided, that it absolves OCC or any other car manufacturer from all of the other requirements that are listed in 537B.3.
So what is the violation then? If the statute says if the nature of repairs or services is unknown at that time, the provider can provide an hourly rate, and that's okay. And if that's what they did here, what is the violation?
So, Justice McDonald, I think there's potentially two violations from that. And there's another caveat to this, that I'm not certain in this case if this is a written estimate that was being provided or an oral authorization. Because if you look at Iowa Chapter 537B.3.
Well, I want to go back real quick
Yeah.
before you run out of time.
Yep.
If that is correct and the statute says they can quote their hourly rate, what are the two statutory violations that you're referring to?
The first one is if you look at Iowa Chapter 537B.3, it specifically says that the estimate that's given has to have a checkbox that says, call me if repairs and services will be more than X dollars. And the consumer is allowed to initial that and put in the amount in there that they want to be provided notice if it's going to be more than those dollars. That did not happen in this
Doesn't
case.
that presuppose that there was an actual dollar figure estimate versus an hourly rate statement?
I disagree with that. I think that
Well, if the supplier says, I don't know what the total charge is going to be, I just know I'm going to charge you X dollars per hour, what purpose does the checkbox serve by saying the amount of the repair is above an unknown cost?
Well, the consumer has the ability to set the budget on their project. And if they go to OCC and say, hey, we want this budget to be $45,000, and then OCC says, hey, Pollers, there's no way we're going to be anywhere close to that. The Pollers can then make the decision and say, we're not going to go with OCC, we're going to go somewhere else.
Okay, and I'm sorry, I interrupted you. So that was statutory violation 1.
Yep.
What is the second?
The second one is, it's under 2.A of 537B sub 3. So it's 573B 3 sub 2 sub A. And that form, at first there needs to be a form, and there wasn't a form. So really there's 3 violations. They violated not having the form, not providing the call me if the repairs are going to be more than, and that form has to have the date, the supplier's name, the consumer's name and telephone number, and the reasonably anticipated completion date. That did not happen in this case. There was no reporting to the Pollers of what that reasonably anticipated date was going to be.
If that's the statutory violation that we find, does that change the nature of your defense? Meaning that, to me, that seems like a very technical violation, and I'm not sure why we would say the restorer is not entitled to compensation for failing to include the date. I mean, that to me doesn't make sense.
I can envision a situation where I would agree with that. The case wasn't tried that way, but if there is reasons why the car needs to be completed by that certain date, that could certainly lead to damages in that hypothetical situation. I believe I'm out of time. Thank you.
Thank you. Mr. Talsma?
May it please the court, counsel, my name is Jordan Talsma, and I represent Okoboji Classic Cars in this case. Okoboji Classic Cars, or OCC, is a full-service classic car restoration company located in Northwest Iowa. The building itself is 45,000 square feet and consists of a museum displaying a collection of restored antique vehicles, as well as an on-site restoration shop. In 2013, the Pollers, who were residents of New Jersey, decided to have OCC restore their 1931 Chevrolet. OCC, rather than providing an estimate as to the total cost of the projected cost of the restoration, instead provided them with an hourly labor charge. The Pollers then shipped the 1931 Chevy to OCC in a series of 4 separate crates. OCC fully performed the restoration work and charged the Pollers based on the time and materials contract that was agreed upon between the parties. The Pollers did not pay the entire balance that was due and instead brought this action alleging numerous violations of Chapter 537B. Now, following the bench trial in this case, which importantly the district court made specific credibility findings that Mr. Sease mentioned against the Pollers related to credibility and in favor of OCC, the district court found that OCC complied with the statutory requirements of 537B.
Yeah, but you didn't give them the form that gave them at least the opportunity to cap the expenses. I mean, the form says something to the effect that it has a checkbox on it, and then says, call me, and you can write in 45,000 or whatever number you want, of course. But they did not get that, did they?
Correct. They did not get the form, and if you look at the district court's decision, it's the district court's position that the form was not required under the language of the statute because the work wasn't authorized under the plain language of the statute, orally or in writing. It was authorized by them shipping the 31 Chevy to OCC. And
here's my problem with this authorization thing. Justice Mansfield was touching on it. I mean, quite frankly, both sides, in terms of construction of the statute, are swinging for the fence. Your view of the statute, I think, is that as long as the work was authorized, that's it. The contract kind of trumps. I mean, you're using contract language, and I understand you're saying there was an offer and an acceptance when they sent the boxes and crates, and we all have seen the email exchanges and so forth, and I get that. But the statute is designed to say, hey, in this particular subject matter, we're going to require certain statutory requirements of disclosure. And if those are not met, you can't just trumpet say, well, it was authorized, because in almost all cases it'd be authorized. I mean, the statute's not going to have any teeth. You see the nature of my problem, and I want you to respond to it.
Yeah, I do. Thank you. A couple points. One, if the form is required, I think, as some of the justices have indicated, it's a technical violation, and that the Polar's argument is essentially that they were not provided the chance to place a budgetary cap on this project, which, as I believe Justice McDonald pointed out, whether that even applies to an hourly labor charge case is uncertain. They also,
But sure it does. I mean, but they were told apparently, I mean, there's evidence in the record that it was suggested to them that, you want to make sure you don't pay more for the restoration than the car is worth, which is kind of a common sense kind of notion. If they would have had any inclination that this thing was going to cost $100,000, I mean, oh my heavens, they would have made other plans likely. I mean, maybe the record doesn't support that. I invite you to attack that part. The notion of capping off one of these projects strikes me as fairly straightforward and fairly common. And even though somebody's working, I mean, if a lawyer's working on an hourly rate, you might say, well, how much is trial going to cost? And you get an estimate of, well, it's probably going to cost X, Y, or Z, even though it's an hourly rate. It doesn't seem to me to be terribly inconsistent, and seems to me to be kind of important in kind of major restoration work.
So a couple points. One, the Polars were given actually the opportunity to see the $45,000 figure, which the district court again discredited, that they were never provided that figure in advance, but they were provided that when they were provided with the invoices in August of 2014, and they saw that the cost of the restoration from those invoices that were provided were basically $45,000 at that time. And importantly, the Polars take no action to notify Okoboji Classic Cars that they believe that, hey, you told us $45,000. That doesn't appear in any of the communication between the parties. They never told OCC to stop working on the vehicle. They actually made more payments and continued to authorize additional work on the vehicle, thereby inducing OCC to continue working on it. And as we put in our brief, basically made the calculated decision that they were only going to pay $45,000 for this vehicle no matter what, and that they were going to continue stringing OCC along to do all of the repairs. And so I think that they were given that opportunity by the invoices showing it was over $45,000. Now, it's our position backing up that primarily this does not, statute 537B does not apply to restoration work simply because of the nature of the repairs, of restoration work versus repairs or service. As I indicated, OCC specializes in restoring antique or classic cars. This is not your typical auto body garage where they're doing oil changes, those types of things.
Counsel.
Street legal, or was it going to be? I'm wondering if it's subject to the registration requirement that would bring it within the statute.
Sure. So the idea, and I think it's indicated in the emails back between the parties, is that they wanted to have some upgrades to the 31 Chevy to make it street legal because they wanted to cruise around in it, not simply just take it for show and not drive it. So they wanted it to be drivable, I believe. That brings up the other point regarding specifically this case and whether the 31 Chevy was a motor vehicle. And not only does it have to meet the definition set forth in 321.1, that it be self-propelled and not operated upon rails, but 537B also indicates that it has to be subject to registration. The testimony and the record is undisputed that this 31 Chevy had never been registered by the Pollars in New Jersey, that they did not have a certificate of title to it, and that basically the plaintiff's position is that, well, it was subject to registration at the time that the parties entered into the contract because it was potentially going to be subject to registration once the restoration work was complete, which I think lends itself to an absurd result depending on how far down we go that chain of logic. So I think that not only does the 537B not apply because of the type of services or, excuse me, the restoration work that is being provided, but also because this particular vehicle, or excuse me, 31 Chevy was not a motor vehicle because it was not subject to registration.
Counsel, I tend to agree with your statement that these kind of restoration services don't really seem to fit within the gist of the statute, which is kind of the one-time repair where the consumer is surprised by a really high price. Here, these people have an ongoing relationship. They're kind of authorizing the work as it goes. All that being said, though, it seems like the cases around the country that deal with this issue seem to go the other way and indicate that repair within the meaning of these statutes includes restoration. So what about our statute specifically would distinguish those cases, or why should we not follow those cases?
Thank you. There are 2 points I want to make. One is the Massachusetts case called Bankian that we cited in our brief that indicates that the restoration company in that particular case was not subject to the limitations of the statute in the Massachusetts case. The other cases, the Levin case, the Wisconsin cases, the California cases, all of those statutes obviously use different language. None of those statutes provide the supplier with the opportunity to state an hourly labor charge, which some of the cases actually bring up, saying, hey, you never provided them with an hourly labor charge. Maybe that would have changed the analysis. And in those cases, the suppliers actually said, hey, I think we can do this for $3,500. They never communicated with the consumer during the restoration or when the services were being provided. And at the end of the deal, provided them with an invoice that was twice as much, something like that. And so this case, I think, is distinguished not only because the statute's language is different, but also because the pullers were, as the district court put it, in the decision matrix throughout this entire process. There are 431 pages of emails that were going back and forth between Mr. Lynn with OCC and the pullers saying, hey, here's some photographs, here's what we've done today. Do you want this piece? We got to order it from here. Do you want this piece? We got to potentially do this. Do you want to upgrade? So there's a constant back and forth where the pullers are authorizing every single thing that's being done to this vehicle.
And Counsel, could you help me with a fact question? At what point, do you know the month and year when Okoboji rang the bell for $45,000? When did they hit that bell?
So the invoices, if you look at them, they're in the record. Originally, the $10,000 down payment was made, I believe, December 27th of 2013. If you go to about July of 2014, so 7 or 8 months later, there was only about 17,000. Well, I take that back. I don't want to get into specific numbers, but I believe it was right around August of 2014 when the invoices were first requested by the pullers, August 5th, were provided by OCC on August 6th. At that point, I believe the number was 49,000, with the credit of the 10,000, making it $39,000.
And although those invoices had not been sent prior to August, I just found I've been looking at the record, many emails, just a suggestion, what do you think? Lots of emails back and forth. Were you wanting a gloss, semi-black? What do you want? Question mark. Also, there was one in particular that caught my attention. Something is pretty pricey. So those kind of communications, the ring and pinion set is pretty spendy at $1,200. Is this something that you would consider? Are those the emails you're talking about, even preceding the actual invoice?
Yes, they are. They are constantly communicating back and forth.
Did you ever receive something that says, I put the kibosh on this, stop?
No, and it's interesting that you bring that up because that opportunity was given to the pullers at least once, maybe twice, saying, if you want us to put your car aside, let us know. I think the first dispute was a little bit of a dispute about, well, hey, you told us it was going to be done by such and such date. And we kind of moved things around and said, hey, if you want us to set us aside, let us know. They never communicated that to us. We also were giving them the opportunity after the invoices came up. They never objected to the invoices. They never said again, hey, you told us we were going to $45,000. What's up with the invoices being above and over that? They never said stop the project, anything like that.
Counsel, the Court of Appeals said that there was no actual damages here. The other side is arguing that there can be money damages or property, and they argue that by virtue of the vehicle still being in your client's hands, they've lost out on property. What do you say to that?
Well, I guess I read the Court of Appeals opinion a little bit differently in that the actual damages, so there's the ascertainable loss as a result of a prohibited practice or act. And then it goes into the actual damages, which have to be proximately caused by the prohibitory practice. I read that as there wasn't any causation to show how, if there were technical violations by OCC by not providing the form, how those actually damaged the pullers. I think that was the basis of the Court of Appeals decision, at least part of it, basically that they weren't able to show that somehow OCC caused their damages, but rather their own conduct caused their damages.
What would be a typical sort of damage then that you would envision under this statute?
Well, if you can say that, hey, you didn't provide me the form, or you told me it was going to be $10,000 or something like that, and it was over and above that amount, I think those are the types of damages that...
But that's what they're saying here. I guess, is there something beyond what they're saying here that you would envision in sort of the normal course under this statute, under 537B?
And I guess I'm just not understanding the question in the sense of they. Are you talking about the Court of Appeals or the pullers?
The pollers.
Right.
So let me ask you a different way. In the normal course of approving a damage under 537B, setting aside what the pollers have alleged here, what would be a normal sort of money or property damage that a party might have?
Sure. So I think maybe going above and beyond, doing unauthorized charges that popped up during the process that weren't communicated to the consumer. So if you go in and you have a surprise $10,000 repair that needs to be done and you do it and you don't talk to the consumer about it, I could foresee that being an item of damage, but that was certainly not the case here. And I see that I'm out of time. Thank you.
Thank you. Mr. Sease, when you're ready.
Thank you. May it please the court. I believe that this statute was designed for situations exactly like this. And the problem that I think we have with Okoboji Classic Cars was it came directly from the testimony of their shop manager, Denny Lynn, when he was specifically asked, it didn't matter what the final total was going to be, the Pollers were responsible for it. And that's what this statute was designed to prohibit, was to stop this unfettered idea that a mechanic shop can just charge whatever they feel like charging. And this is exactly what was designed to prevent, to happen, was these instances. And I want to talk a little bit about and follow up some.
Let me ask you just one quick question. In August of 2014, you're getting these invoices, they're piling up. You're starting to learn that this is going to be, you meaning your client, starting to learn this is going to be very expensive.
Justice Apple, if you could face forward, then we'll hear
Yep.
every word you say.
I'm sorry. By then, they knew that this thing was really, really mounting up. And they knew additional work to be done because they were talking back and forth about, lots of stuff. Why didn't they speak up then? I mean, at that point, so they sent a total of $45,000 and they knew there was going to be more expenses coming. They didn't say, oh my heavens, this is blasted through our budget. Instead, they paid several checks and continued to talk about future payments or future efforts on the car. Doesn't that give you pause?
Well, so that's exactly where I was going, Justice Apple. If you look at just the dates of the invoices and what was going on, that tells one story. But if you look at the email communications and what was happening, it tells a little bit of a different story. What happened was on August 5th, I believe the Pollers sent an email saying, hey, we haven't gotten an invoice yet, what's going on? And then there's this list of invoices from August 6th. And then I want to fast forward a little bit to October 7th, and it's on page 116 of the appendix. It's an email from Deb Poller following up from a phone call that happened. And specifically, it's saying again, I repeatedly asked for an itemized bill, which we asked for on 9/11/2014, and to date have not received. It was agreed that such would be coming, and we sent a check, fulfilled our side of the agreement, still waiting on them, on you. And so the Pollers are still kind of questioning what's going on at this point. And as Chief Justice Christensen mentioned, on at least August 6th, they're getting a bill that they're at $49,000, and then a couple of weeks later, now they're at, I think it's $64,000, plus the $10,000 they've already paid. They're already at $75,000 on August 28th, and the Pollers are having communications, hey, we want some itemizations to back this stuff up.
But did they pause at that point? Okay, I agree with everything you said. If I take that for what you just said, did they ever hit pause at that time and say, until we figure this out, stop the bleeding? Did they ever do that?
I don't believe there's anything in the record that where they specifically affirmatively said no to that. But as I mentioned, they didn't actually get the itemization that they requested until October 7th and 8th, which is on page 290 and 297 of the appendix. And that's when they received those itemizations and everything that they were requesting. And if you look, up until these invoices started coming in middle to late August, there was a lot of communications that were happening. But after this time period and requesting upgrades or anything like that, there was virtually none. A lot of the communications that were occurring at that time was OCC sending photos, just giving updates of, hey, we've got the upholstery installed, or here's what the wheels look like installed, or something to that effect. And in the grand scheme of things, we're only talking about an additional $10,000 or $20,000 worth of, or actually about $30,000 of work. So a third of the work was completed in this last little bit. So majority of the work happened without any knowledge to the Pollers of what this actual cost was going to be. I see my time is, well, I got a few more minutes yet.
You've got 5 seconds.
Oh, okay. I thought it said one. Then I'd just ask the court to reverse the district court. Thank you.
Thank you. The case of Pollard versus Okoboji Classic Cars is hereby submitted, and we will take just a brief pause and allow there to be preparation for the next case to take the bench, or to take their seats.